for the stragglers to join us. The next topic is one that's near and dear to my heart, is that if you have a client who's going to be buying a business, somehow they have to finance it. And if they can't finance it, you don't have a deal. And if you don't have a deal, then you're not going to get paid. So one of the things we need to talk about is how to finance it. And really, there's a question of, to what extent is this a business, is this a legal issue or not? And one of the things I found in my career, and it took me longer to learn than it probably will take most of you, or has taken most of you, is that our clients, especially smaller clients, entrepreneurial clients, they don't buy and sell a business that often. They do it once or twice in their lifetime. And if your practice is going well, or if it's been a good year, hopefully we're doing it more often than that. And so you can bring, besides just the bare bones legal advice that we've talked about, clients oftentimes are looking for business advice, and they can get it from lots of sources. But one of the places where I find clients looking for is sometimes to me for business advice as well. And in the first years of my practice, I was, I think, a bit reluctant to give business advice on the theory that I didn't know very much about business and who was I to be giving them advice. One of the things I found out was I still don't know very much about business, but I'm less reluctant to give advice now. And they seem to be prepared to accept it. And I think in large measure, it's just common sense and experience. And you can bring some of that if you've been involved in financing a business before or in dealing with bankers. Sometimes you've had more experience than your client has had. As I said, particularly if it's a small or medium-sized business, if it's a young person, if it's an entrepreneur, they haven't had as much dealing as you have. So in thinking about the kind of value you can bring to a transaction, sometimes it's not purely the legal advice, but it's business advice as well. And I think that we'll focus in a lot on that on this topic. We have joining us, all the other speakers on the program today have been lawyers with one exception. Karen Gufler is going to be part of the next presentation. So I'm particularly grateful to Karen for joining us. Karen is head of the National Bank of Canada's Toronto Technology Group. And in that capacity, she's in charge of the bank's lending in the Toronto area to high-tech companies. So she's the sort of person who would eventually have to sign off on a loan to our client to acquire Cyberstore Inc. So she's been through this sorts of thing more times than any of us in the room have been, and she's seen more proposals and more deals go forward. So we're grateful to her, and we're interested to hear what she has to say. Joining Carol is, joining Karen is Carol Pennycook. Carol is a partner at Davies, Ward & Beck. She practices in the commercial corporate area with her primary specialization is in financing transactions. She's also the coordinator of the Advanced Business Law Workshop at Osgoode Hall Law School. At the present time, she's chair of the Commodities Future Advisory Board, which reports to the OSC. And she's also on the editorial board of the Canadian Corporate Precedents and Canadian Securities Law Precedents, which you've seen in the library are put out by the Davies Ward firm, and I use whenever I need an authoritative precedent, and so I recommend them to you. I'm not sure how Karen and Carol will do this, but I'll turn the floor over to them.
Thanks, Greg. I'm Carol Pennycook, and thank you for the introduction and for the opportunity to be here today. In looking at the fact situation, it wasn't set out as to who the borrower would be, and normally in a transaction like this, your client, whether it would be the bank or the borrower, would come to you with a completed term sheet that would set out the basic business terms and conditions of the deal, as well as a number of parameters which would reflect the expectations of the bank. But that really only gives a framework and leaves a lot of room for the counsel, whether you're acting for the bank or the borrower, to ask questions and to help both clients structure the lending transaction in a manner that provides adequate flexibility for the borrower and lets them achieve what they want to achieve, but still adequately protects the lender. Probably the first question to ask in a case like this is who is going to be the borrower. Now, the materials that I've provided to you have suggested that Cyberstore itself would be the borrower. We know from the financial statements that we have that Cyberstore already has financing in place, and we're assuming that it may be the purchaser's intention to take that financing out to the extent that it's redeemable or repayable at a reasonable price without a premium that makes that is too large a disincentive, or alternatively the purchaser might be wishing to provide financing which would combine the financing needs of both businesses, the purchaser and CyberStore. There's also a possibility, because of CyberStore's California operations, that CyberStore has a U.S. subsidiary that carries on those operations, and that company may also need funding. So the first question again is, who is the borrower? If CyberStore seems the natural answer, remember that if you're thinking that you're funding the acquisition, then you're going to have to contemplate and sit down with the clients and say, well, how are you going to do the daylight loan facility so that the purchaser can finance the acquisition so that it owns 100% of the shares if CyberStore is in fact going to be the borrower and lend money up so that you don't have any financial assistance issues. So there would be a period of time in that case where you would necessarily have to have some kind of daylight loan provisions or some other provisions to bridge that gap. Part of the question of who's the borrower is which entities need the money. We know that the parent needs the money to complete the purchase. We're assuming that CyberStore, perhaps both of them, need funds for their ongoing business operations or to take out the existing financing, or a combination of both. And the subsidiary may need money to carry on the business operations in California. So there is a question of who needs the money, how will it flow through, and in looking at that, there are all sorts of possibilities. There could be multiple borrowers, there could be one borrower who on lends. Probably the most important issue in determining that structure will be tax or regulatory impediments. So for example, you may not want a Canadian lender lending directly to a U.S. subsidiary, because that may give rise to withholding tax issues if in that case, or there may be thin capitalization issues or other issues that would preclude direct loans, and you may want to look at structuring issues in that regard. Once you've determined who the borrower is, the next consideration when you've got a corporate group like this, will there be any guarantors? And a good portion of that answer will be based on what is the bank making its lending decision on. If it's looking at the aggregate group of corporate assets, then of course you'll need to have guarantors so that the bank will have recourse to the entire corporate group and to the assets of the entire corporate group. There may, in some circumstances, be perhaps personal guarantees of personal shareholders who are, in this case, they would be shareholders of the purchaser, or depending on the financial structure, and this CyberStore actually has a very strong balance sheet, so in that case, it may very well be that there are no personal guarantees. If there are to be personal guarantees, if you're acting for the borrowers, your clients will want to ensure that those personal guarantees are as contained as possible, that they have limits on them. There may be a time when those guarantees would be released based on financial performance of the corporation, and if that has been negotiated, it's very important to include that in the documentation because a personal guarantee, first of all, usually puts a great deal of extra stress on the individuals involved, and it also impacts their own ability to borrow and do their own financing on a personal basis. If you have subsidiaries, even if you're considering, do we really need a guarantee from the subsidiary? It's a small part of the business. If the assets of that subsidiary are an important part of the business, either because of the percentage of value or because they have a critical component of the business that makes the rest of the business more valuable, then it may be important to have them as a guarantor and perhaps to provide security. If they are not a guarantor and if they've not provided security, but perhaps the borrower has given a pledge of the shares of that subsidiary, keep in mind that to the extent that subsidiary goes out and has its own creditors, that the lender at the parent level is going to be structurally subordinated, because the creditors to the subsidiary will have prior rights, even if they're unsecured, over someone who steps in merely as an equity holder. And to deal with structural subordination, there are a number of ways. One of the ways, the simplest way, is to have a guarantee so that you're on the same level as other unsecured creditors of the subsidiary. Another possible way is to have the parent, instead of using funds, putting funds in by way of equity to on-lend the funds and therefore have a receivable and rank pari passu as an unsecured creditor with direct creditors of the purchaser. Okay. Again, in the financial statements, if we are lending to Cyberstore here, the financial statements indicated that there were first mortgage bonds, so there is another lender out there with first ranking security, and that will be something that needs to be determined as to whether that's going to be repaid or whether the new lender is prepared to have a second charge subject to that first charge. Also, the terms of that existing indebtedness, if it is not going to be repaid, will need to be reviewed very carefully to ensure that putting in the new credit facility isn't going to breach terms for perhaps a negative pledge or perhaps a restriction on indebtedness that would result in an acceleration of debt that you weren't planning to repay. Turning then to some of the deal points, in preparing the loan agreement, the lender will provide you with all the information regarding pricing, interest payment, what interest rates are available to the borrower, what kind of notice they have to give for drawdown, those types of conditions. Very often a term sheet will say standard representations and warranties for a transaction of this nature. Standard means that you're expected to, as counsel, advise either of your clients, be they borrower or be they lender, as to what would be normal or typical in these circumstances. The lender in this case is very likely to have concerns regarding representations and warranties that are quite similar to the concerns that the purchaser had in purchasing the business. The lender is going to want to have representations and warranties that tells it about the corporate structure, the current potential. So you'll have normal representations regarding the corporate status of the borrower and any guarantor, the capacity of the borrower and any guarantor, the fact that the borrower and the guarantors have properly authorized the borrowing and granting of security, that they've obtained all necessary consents. There will also be representation regarding the assets of the borrower and the guarantors. The financial condition, for example, that the financial statements accurately reflect the current financial position of the borrower and the guarantors, and that there have been no material adverse change to the last financial statements delivered to the lender. There'll also be representations relating to potential contingent liabilities, such as, are there any unpaid taxes? Are there any potential environmental liabilities? Are there litigation claims that are pending, which might create a claim against the company and affect its value? In any situation, and these kind of representations are pretty much standard regardless of the nature of the business of the borrower. But then you get into specific representations which relate to the particular borrower and the type of assets that it has. And in our case, I think that the intellectual property assets of Cyberstore, and indeed of the purchaser here, are probably where the greatest value lies. Now, the financial statements show that there are a number of hard assets that that Cyberstore has, but I think Karen will probably tell you that it is quite common in the high-tech industry for a company's value to be primarily based on its intellectual property, that they may have very, very few hard assets indeed, at least with smaller businesses. And some of the hard assets they have, even their computers and so forth, may be leased, so that it's not really an asset that has a lot of value to the lender. And the sample loan agreement that I've given you, and this is very much just a sample of the kinds of things in different areas that you might see. It's by no means intended to cover the waterfront, and there are certainly things that might be appropriate in some circumstances and not in others. And there are certainly, in all areas and representations and covenants and events of default, things that would need to be added based on the deal and the parties involved. But in this case, I put in a number of representations regarding intellectual property, which are similar probably to the ones that you would see in the purchase agreement, that you wouldn't find in a company whose primary business was manufacturing of carpets, or was a retail chain that had very little intellectual property. You would normally see, or at least for the next few months I think we'll continue to see, year 2000 compliance representations, but you would see far fewer IP representations. So what I've done here is put in representations regarding listing of the borrower's intellectual property so that the lender knows what there is, particulars of registration of the intellectual property rights, providing that representations regarding the assignability of those intellectual property rights and the ability to grant security interests in them, because if there are rights which terminate if they're assigned, then the security interest granted to the lender has no value because they disappear if the lender goes to realize on them. So that's a very important aspect. And it is not uncommon for various licenses and so forth in high-tech industries to preclude assignment, even in a circumstance where it's bona fide security to a third party. There are also representations regarding the validity of the intellectual property, that the property hasn't been used or enforced or failed to be used or enforced in a manner that would result in abandonment or cancellation or unenforceability of a particular license or right. There's references to the rights of third parties to intellectual property, which I know other speakers have talked about, and the importance of, if there have been consultants who have developed some of this property, have they executed a written agreement where they've granted, assigned, and transferred to the borrower their rights and interest in the intellectual property that they created, and that they waived all moral rights. If they haven't done that, again, that may not be property of the borrower. It may be property residing in the consultant. Representations regarding no claims of infringement or breach of intellectual property rights, and representations regarding their right to license or sublicense, as they're currently doing, to their own distributors or purchasers or end users. Put in some Y2K representations, which are pretty standard for everybody these days. And in this case, again, because of the nature of their business, we put in some representations regarding the fact that the business's computer systems are free from disabling codes and viruses, and that they've got in place appropriate backup and recovery plans. Again, on the assumption that really the property that is of value here and that the lender is relying on is the intellectual property, so they want to make sure that it's safeguarded. There's also an additional Y2K rep in here regarding the compliance of their products, because this company, Cyberstore, is selling the Pocket Attic and the Track Buddy and other products. It's important to know that those products that they've sold to third parties are Y2K compliant, or that they've made arrangements so that come January of next year, they're not going to have a bunch of warranty claims that their product is deficient. So that pretty much takes you through representations and warranties. Covenants. Normally the term sheet will set out a number of specific covenants that are important to the lender, and then it will often say, and other covenants typical for a transaction of this nature. So you would look to usual covenants, which would almost invariably include financial reporting covenants, and the lender and the borrower will normally have negotiated annual reporting, quarterly reporting, and depending on the business, perhaps monthly reporting at certain levels, and you can build that in. In this case, we've also put in typical covenants regarding the maintenance and protection of the assets and carrying on business in a prudent manner, such as maintaining insurance and so forth. And then we put in some additional covenants that you wouldn't necessarily see depending on the nature of the business, that again relate to the specific intellectual property here. And a lot of them are similar to the representations, only on a going forward basis, saying you are going to ensure that your computer systems have proper backup. You are going to ensure that you've got appropriate source code for all your software and it's properly licensed, and that you're going to have access to it to copy. You're going to do all the appropriate registrations and maintain those registrations of your rights so that the lender can register their security interest and so forth. And again, there are a number of covenants here that you wouldn't necessarily see if the borrower was in a business that wasn't reliant on their intellectual property right. The security, we've contemplated security would be needed in this case by the lender, and we've talked about a general security agreement, and again, I've already mentioned, if you're not taking out all the existing financing, you have to look at the securities that is there and see what security can be given. We've talked about there may need to be a specific assignment of receivables or certain contracts. The lender may very well want to be endorsed as a loss payee on insurance, including business interruption insurance. Depending on the nature of the business, the lender may require key man insurance to be taken out by the borrower and assigned to the lender as security if there is a key employee or employees who are fundamental to the business. That may be something that the lender requires. On the intellectual property side, we would normally recommend that a separate intellectual property agreement be used to take the security interest in the intellectual property. It would be similar to a general security agreement. You're still granting, the borrower would still be granting a security interest in that property. Likely, and people will say, well, why? Intellectual is property. It's certainly not real property, therefore it must be personal property, and so you've got a GSA and you've got a PPSA registration. What more do you need? Which makes perfectly good sense to me, but there is some dispute with respect to intellectual property that hasn't been resolved yet in the Canadian courts as to whether a bona fide purchaser for value without notice would be bound by any PPSA registration. So we would recommend that a separate agreement be entered into, that a notice of the security interest in the intellectual property be registered at the Canadian Intellectual Property Office, which is kind of the amalgam for patents and trademarks and everything else, because there's obviously no PPSA equivalent on a federal basis. But here's the conundrum. You can only register notice of your security interest if there's a registration of the intellectual property interest. So that's going to be part of your due diligence for the lender. It is not uncommon at all. In fact, it's probably more common for these registrations not to have been made. And also ask, what about, for example, in your pocket attic? Has the embedded software been registered there? Quite possibly no. So depending on the importance, there may be a fair amount of work to do to get you to a stage where you can register. Then on events of default, again, you'd expect the usual payment defaults, covenant defaults, possibly cross default to other debt, insolvency events of default. But there may be other events which could affect value or priority, such as judgments against the company, seizure of property, a guarantor contesting liability. And although it's not in here, if there's a particular intellectual property right that is very important to the lender may be looking for an event of default that would relate to a claim at a certain level of infringement of rights or lack of validity of any license granting those rights. Special concerns relate not just to this particular business, but to any business. The lender, again, depending on the key individuals here, may want an event of default that relates to change of control. They may feel very strongly that they are lending as much to the key management or to the key shareholders as they are to the business. And therefore, if there's a change in control, they may want to revisit whether or not they're prepared to continue the financing. Similarly, a loss of key personnel, a loss of trademarks, a loss of patents, or a determination that one of the parties here is infringing the intellectual property rights of others may cause the lender to say, we need to revisit this, and this may be an event of default that allows us to accelerate our loan. And I think on that note, I'm going to let Karen speak to you, and she can talk to you about what happens in the real world.
Good afternoon. Well, I have to tell you, what Carol has just described is pretty much what happens in the real world. I thought I'd tell you a little bit about what we're doing, just to put it into context. As head of the high-tech group here in Toronto, we're primarily banking mid-market technology companies. So our transaction size would probably range from the 1 to 15 million. You might get smaller and a little bit larger, but that will be the bulk of our transactions. Having said that, although they're not overly large relative to most companies that you see being acquired, they're still not simple transactions to paper. I'd never attempt to paper a file in the high-tech world with standard bank documentation alone. I could do that in traditional industries, take your GSA, your book debts, your insurance and fire insurance and all that kind of stuff. I will not do it in this sector. So I always use external legal counsel all the time. So I guess then it becomes evident that it's very important to me to have good legal counsel. So I want to talk to a little bit about the role that they play and what I look for in our legal counsel. As you know, a properly documented, a lender stands a chance of some recovery in the file. A little bit of recovery. If you know anything about recoveries, you might collect 10 to 20% of your receivables and 25% of your inventory. A little bit more here and there, but generally you're never going to come out whole if you're looking at just straight commercial assets. If it's poorly documented, you're going to collect very little, and not only that, not only does the bank take the hit, but the account manager gets that accountability follows him or her, and it will follow you regardless of whether you're not on that portfolio or not. So a good legal file, a good documentation becomes really, really critical. I've been there, I know. It also can really badly damage a legal firm if it's not properly documented. I've seen a case where I was with a financial institution and a file was not properly documented, some major holes on the intellectual property, and that firm was barred from papering any more of our files. And that was not necessarily just, the law firm's fault singly, but that is an outcome that, you might want to think about. So when I look for legal counsel, I do look for somebody who's got experience in properly documenting security interest, and very particularly intellectual property, including source code escrow agreements, copyright mortgages, trademarks, anything along those lines. We do not have standard bank documentation that typically covers that off. So we really do rely on you to come up with something that's appropriate. I also look for somebody who's got a solid business approach. We get a lot of smaller, more junior, less experienced management that's being bought out, or they're trying to buy out another company. So you're getting a lot of back and forth with the lawyers, with the buyers, the sellers. So you really have to I look for a lawyer who says, well, Karen, their legal counsel wants this, and I think that's okay. You're still adequately protected because you have this here and that there. I don't profess to understand all the pieces of it, but if I have somebody who can kind of explain to me why I'm still protected and what's my downside and what's my upside, I'll run with it, and that just makes good common business sense. And the last lane, but not the least important, is somebody who can advise me on potential holes in the security that's been outlined in the term sheet, because that's basically all you'll get from me. I'll ask you to please paper this file for me and come back with what you think's appropriate. And any other risk that they can see. The lawyer that I use to paper most of my files right now, he'll always go through and he does some homework on the company, and he does some homework on, what it is that they're selling, if it's a software company, that they're developing this or that. He'll always do some homework. And then he'll say, well, Karen, have you thought about this? Sometimes I have, sometimes I haven't. And that's where it's really a value add to me. I've been I'm a 22-year banker, so yes, I've seen a lot of files, companies bought and sold. But in these new emerging industries, they're all so very different. The risks are different. The legal issues, the tax issues, everything. So we really value some solid input. It doesn't mean that because I've been there for 22 years that I know everything. I don't. And you're going to run into a lot of junior lenders as well who really don't have necessarily the background. So the role that you play, I just can't emphasize that enough. Okay. In the case of Cyberstore, we've primarily been talking to operating and term loans. And as a mid-market lender, most of my product lineup is operating and term loans. I mean, we do have the SR&ED tax credits and contract financing and that kind of thing. But mostly we'll see that as well as acquisition loans. So I thought I would really highlight the security here because in the text it shows that they have GSA and an assignment of book debts and insurance, and that's all wonderful. But in any technology company, I will not budge on having a first rank or a pari passu rank on the intellectual property. I'm going to tell you why. I'm going to give you an example of a client that I had in 1994. And this predates most of the establishment of the high-tech lending teams at all the banks. So I had a software developer, and he had been in business for 25 years. Anybody who lasts that long, you figure they're going to survive. You know, they've built a product platform. Well, they were in the process of building another product platform. Their existing product platform still sold to a certain segment of the market, but this was geared at another larger segment, and they had external sources to fund it, i.e. the users of the software product. They had gone along, they had spent somewhere in the neighborhood of $13 million, and I'm talking a company whose sales revenues were less than $10 million. So there had been a real chunk of change put out to develop this product. And they were running out of money, and some third party, they found another party willing to provide them $2 million to just finish it. We're 95% there. I've learned you're never there until you're 100% there when you're developing software. It just isn't the same. That 95% doesn't count. They ran out of money. They never finished it. In the interim, in order to get that last $2 million, the debt provider said, I want first rank on the IP. Before the, like I said, before the high-tech times, I had receivables, I had personal guarantees, I had coverage 3 times, I had tax credits, you name it, I had it. And I said, okay, fine, there's got to be some value left. Well, guess what? Off they went with the intellectual property. My receivables were worth nothing. I think on $1.5 million we collected $150,000, because if you're not there to service the intellectual property, i.e. the software, nobody pays. I'll give it back to you. I don't want it anymore because nobody's there. There's no upgrades. So you really need to make sure that you're tracking the receivables, my commercial security, to the IP, okay? I did get paid out, by the way, but it was from accrual SR and EDs. Took us 2 years. But it just goes to show you that the value that we all thought in receivables and inventory, in the case of high tech, it has to follow the owner of the intellectual property. So I'm still arguing with somebody today. I've got a little itty-bitty credit. I'm doing $1 million, and they want to pump in $3 million so these folks can, you know, finish this product platform of theirs, and I'm still saying, I need my little hook into the IP. We're going to do it on a pari passu basis. But so, you know, that's why. And when you explain it to them, because if you think I'm not getting pushback, I get tremendous pushback. And when I start explaining that, I always get it. And I generally don't lose the business that I'm bidding on when I take that stance, okay? So, but that's the thinking behind it. And it's worked, and there's a very real purpose behind it, believe me. From a reps and, okay, I'm gonna now talk about some of the risks that I've seen in the security, and I think probably I've talked to why it's so important. I had another file where my security vanished, okay? The company went into bankruptcy, unfortunately, and I thought I had some wonderful title to, it was an entertainment company, so I had some wonderful title to all their shows, et cetera, that didn't survive bankruptcy. I learned the hard way, and that was a major hole in that particular file. And you know, you sit there and you think you've got it covered, but that's where the review of the documentation comes into play. So when I now put into my conditions precedent in a term sheet, or my conditions, covenants, whatever, I always say, I want to see the shareholders agreement, I want to see the distribution agreements, I want to see the purchase and sale agreement, the license agreements. I need to know, are there any surprises in there? I really didn't have to do that to the same extent in traditional banking. But I'm finding that you go through some of these things, you go through venture capitalists, you know, when they invest in high-tech companies, and I think out of all my clients, there might be 1 or 2 that don't have, you know, VC money, or if they're not already public. They've got some really unusual covenants that I've found. I have structured deals that some of my covenants are in contravention of the shareholders agreement. And those are things that when you do go to crystallize on your security, if you really have to, then that could cause you some problems. So As a lender, I mean, what Carol has said is really very, very true. We have some different ones in there. Just look at them, and that's the reasoning behind it. It's not because we want to be a pain, we want to be difficult. It's just that when you crystallize on your security, and it's not going to be tomorrow after you've papered it, it's generally 2 to 5 years after you've papered it, you need to have that backup there. You just really do. On the source code, just one point. I know it's covered under the GSA, but from a practical standpoint, I can't get somebody in to deal with the software if they don't have access to the source code. And unless you get the company's cooperation, what's the point? You know, it's really not a practical thing to do. And again, the last thing that I've got up there is that you want to make sure the company actually has a direct right to the software. If you have developers in-house and somebody's bought the company or it's being sold, if their employment contracts don't touch that, you really need to know that there's not going to be a challenge to it. That's very, very important for us. Okay. Now, so I think I've pretty much talked to all of that. I've really only wanted to give you a couple of examples of the cases that I've dealt with. I mean, term sheets in our industries will not necessarily be as straightforward as some of the more traditional industries. You will have financial covenants, but you may not have the same financial covenants. In cases where I don't have a lot of tangible net worth because they've just used most of that to expand a product platform, I will use liquidity covenants going forward. So I will use things like, if you haven't met your projections, up to 90%, then that could be a cause to review the file. So there will be different things that will come out of that. So from my perspective, if you have clients in the high-tech industry dealing with banks, that's not necessarily unusual. And it's just a matter of kind of figuring out from a practical standpoint, how do you apply it and then take it forward. So that's really all I have for today. So thank you.
Does anyone have any questions for Karen or Carol? Some over here.
A daylight loan is really a loan that happens during the day. It's covered within the same daytime period. It's not overnight, so that you have to pay out money at 8 o'clock in the morning and it gets covered at 4 in the afternoon.
What often happens is if you're trying to deal with the financial assistance issues which preclude a company from loaning money or providing financial assistance to purchase its own shares, you may, if Cyberstore here was going to be the borrower, the bank may be prepared to lend on a promissory note at 10 o'clock in the morning when the transaction closes to the purchaser. Then that promissory note is repaid at 2 p.m. when you've got a wholly owned subsidiary that signs all the security documentation, and that whole thing is in place, and you've kind of got this escrow period in between. Actually, often it's only an hour. But if you don't take that step, then you've got a risk, and you, counsel, I think, are responsible if you haven't pointed out that risk, that the whole thing is that loan up to the parent is not valid and non-enforceable because you've had the financial assistance, you've breached the financial assistance provisions. So the form can be, believe it or not, as important as the substance and things like that.
Carol, just one other thing about structuring, just to stay on the same point as who does the borrowing. Lots of transactions, especially where you do a share purchase, you'll incorporate a holding company which borrows the money, does the acquisition, and then amalgamates on the day of closing with the target company. And what that allows you to do is get the interest deduction for that borrowed money into the target company, which is earning income, hopefully. And so that's a common structure as well, to have the holding company borrow the money, amalgamate with the target company on the closing date, and the bank is really looking at security over the assets of the target company in just the way that Karen's gone through. But instead of lending the money to the target company, you lend the money to the acquisition company and then amalgamate it with the target company on the closing date.
And that's very important, because I know a lot of times you say, well, we'll just have the purchaser borrow the money. Well, the purchaser is is just a holding company and has no income, then they can't deduct the interest expense. And that's why you may want the operating company as a borrower. And the amalgamation may very well be the solution, unless, of course, you have critical agreements that say it disappears if, you know, that an amalgamation is just like an assignment, and if you do the amalgamation, that's viewed to be an assignment and you lose your license rights. So in deciding to use that structure, be very, very careful. Intellectual property agreements, some of them, in my view, are just weird with respect to unusual assignment rights and so forth. So you really need to be careful. You can't make any assumptions.
Are there other questions? There were some hands up here before. Yes? I'll just repeat the question, Carol, just so that we get the this for everyone else's benefit as well. I think the question is, if you have a GSA taking security over all of the corporation's personal property, why would you insist, and why would Karen insist on having a separate security agreement just on intellectual property? You might want to use the mic to answer yourself.
The reason, there are actually two primary reasons that I think. First of all, when you're taking a security interest in certain intellectual property, you need to be very careful of how you take it. You want to take a security interest. You do not want to take a mortgage. Again, for example, if you have a trademark that's part of your intellectual property, and if you took a mortgage as opposed, if you took a security interest in that trademark, that's fine. If you took a mortgage of it, then legally that's an assignment of the trademark. Now, if you've assigned a trademark to a third party, that trademark is no longer unique. If the trademark is no longer unique, then anyone in the world can use it, and you can't say, well, you're breaching my trademark because it's not unique anymore anyway, and you were the one who gave it away. So you've just created a real problem. You've lost value for the company, and you've given the lender something that no longer has any value, so you haven't, both parties suffer there. So we think that it's easier to safeguard. I think most of us, or many of us, will have a standard form of GSA that say, we hereby mortgage, pledge, charge, hypothecate, transfer, assign, and take a security interest in everything. And that's why you could certainly accomplish it in a GSA, but frankly, I think it's easier to be careful and less likely to make a mistake, an inadvertent mistake, if you deal with the intellectual property separately. There is doubt in Canada as to whether intellectual property is treated as personal property under the PPSA, so that PPSA registration would create priority over a bona fide purchaser for value without notice. Now the trick is without notice, so you say, well, how can I give notice? Register in where you can register in the intellectual property rights notices. You still won't be able to give a clean opinion that this creates priority, but at least you've done everything that you can do. I'm not saying not to do the PPSA registration. You do that as well. But we would certainly recommend that you at least consider taking an intellectual property, a separate assignment by way of security interest of that intellectual property. And I think, Karen, you would agree that in your case you'd demand it.
Well, particularly always, and it's particularly important with getting that source code for software, right, because it's just hard to deal with it if you don't have it.
For those of you who may not be particularly familiar with source code, it is really kind of what I call the manual of how the software works. So it's often put in escrow and updated as software is enhanced. Then the source code is updated. And what Karen was saying, if the lender has that source code in escrow, then if they have to realize on the security, they've got the blueprint, if you will, or the manual of, okay, how can we take this software so that it's usable, and we can give it to some technology wizard who can say, oh yeah, I see how they've done this, and we can use this to enhance it or to otherwise use it. So it's really the blueprint, if you will. Yeah. Right. It normally, I mean, frankly, it depends on your negotiating ability and who's important to who. And a third party might be trying to use these negotiations, not because they really object, but because they're trying to use it as leverage to get more money or to change the terms of their license. So the negotiations often have very little to do with the assignment by way of security to a lender. The real way to do it is to deal with it up front. So if you are fortunate enough to deal with your client when they're entering into one of these agreements, to negotiate it right then, that there's an ability to assign by way of security. If you've really got a third party who's legitimately concerned, then it often helps to sit down with the lender and the third party and say, look, all we want to do is be able to realize on our security. We don't want to infringe your rights or anything else, and try and find out what their real concern is. And often the lender can still take the security interest but address their concern. But I would guess that more often than not, what their real concern is can I get some more money out of this or change the terms? Like, do I have a leveraged position here right now? Karen, I don't know what your experience is.
Well, I was going to say, that's very much what we see, and particularly with the sub-debt providers. So when we get, and that's all we get, is new transactions, we're at last minute very often having to change the terms and conditions or modify them slightly. So I forgot what I was going to say. Sorry, I forgot what I was going to say.
With the third party.
Yeah, third party. So it's not uncommon to go through that. And so what we always do, or certainly what I always do, is I make up my mind, like, what is it I really must have and what can I move off of? And this is where I get back to the lawyer that had the business approach, because then he'll say, well, it doesn't make a difference if you have this or not, or, you're protected in this other way. And that's really what I was getting at, because we run into that a lot.
I've seen one situation where the third party wasn't budging, and we got them there by saying that instead of giving the security interest, the lender got a right to really purchase as part of their realization for a reasonable fee, so that they could then, if they were into a realization situation, they could say, is it worth for us to pay this amount, which I can't remember what it was, but say it was $20,000, because if we put $20,000 in, it may make a difference of $100,000 or $200,000 in our realization. Or if it's not, well, fine, we won't take it. So the third party didn't get money up front, but they thought, oh, well, I may get it later. That's really, and that's not something I would encourage, but it was kind of a last-ditch effort. Yeah. We do, yes. 10 years ago we didn't. You didn't really even think about it, but we do that. We carve it out just the same way as you do the except the last day of a lease of any real property. You say, but we have everything, but we don't have the last day. So we would carve out trademarks and patents, and often you'll see JSAs that carve out an assignment of contracts where you need consent. You say, but you hold it in trust and blah blah blah. So you can do the same thing with software. Thanks.
Thanks very much, Karen and Carol, again, for giving us a perspective of looking at a transaction from the point of view of a lender and lender's counsel. The last topic, and we'll go through it reasonably quickly, is indemnities. And we've talked so far today about representations and warranties and all the stuff you have to do putting the deal together, all of the due diligence you're going to do, all of the closing conditions, getting the financing ready. And indemnities is kind of what happens if something goes wrong. And I don't know what your experience has been, but my experience was I had practiced for a long time before I was really forced to read the indemnity sections of an agreement of purchase and sale all that thoroughly. It tends to be that they come at the back of the agreement, and by the time you've finished reading 40 pages of boilerplate and you come to the indemnities, your eyes are kind of glazed over, and they tend to be written in very dense prose and with 2 or 3 periods on the page, and they're difficult reading, and they often don't get negotiated a lot either. Everybody knows there are 2 things you look for. You look to see what the limit is, what the cap is, what the threshold is, and how long they survive, and we talked about that a little bit already. And it tends to be, you sort of kind of go over them fairly quickly, and you say, okay, are they going to last for a year or 2, and what's the limit going to be on indemnification, and skip over the rest. And I think, and I want to spend some time going through it with you today, I think it's worth spending a little more time looking at the indemnity provisions. It's worth focusing in on them a bit. This happens to be an area where you don't need any specialized knowledge. You don't need to know any IP law. You don't need to know any tax law. You don't need to know anything else. It's just straight reading and contract law. So all of us are equally as expert in the area of indemnities as anyone else. So it's the sort of thing that as a general practitioner you can be good at. It also tends to be something we don't bring our clients into enough, I think we sort of think this is the part of the negotiation that the lawyers can handle themselves, and they don't need the client inputs, and the clients are gone off to work on other parts of the business. But I think as we look at it, there are things that we need some input from our clients on, and we need to bring to our clients' attention as well. I guess stepping back a minute and thinking about the indemnities and thinking why they're in the agreement, what they're really there, Hugh talked earlier about representations and warranties sometimes being a way of allocating risk in a transaction, of identifying the risks and saying, is this a risk that the purchaser assumes, or is it a risk that the vendors keep with them? And the indemnities are an attempt to say, once you've decided who's going to bear the risk, to carry that intention into reality by allowing an action to take place and allowing your client to receive money if the vendor has kept the risk and it's been one that's been allocated to him. But we should remember that indemnities aren't the only way to achieve this result. In fact, they're not always the best way to achieve this result. There are lots of other things for us to be thinking about. An obvious example is you can hold back part of the purchase price. You don't have to pay the whole purchase price at closing. You can hold back some portion of the purchase price for some period of time, whether it's 60 days or 90 days or a year. And in large measure, that's better than any indemnity you're going to have. You'll couple it with the indemnities, but it gives you some funds that you have access to, and we'll talk about set-off a little bit when we think about that. The other thing is, lots of times, if the purchaser is having trouble financing the business, your client may be able to take a note back for some portion of the purchase price, and you may be able to work it into the financing. Your note that note back may be just the thing that allows the deal to be financed and allow the transaction to take place. And again, with set-off and that note back, you may be able to have as the purchaser, you may be able to have recourse to funds without having to worry about going to court. I guess the other thing, when we're just thinking about why the indemnities are there, is what happens if we didn't have an indemnity there at all? I find in agreements of purchase and sale, we've always had indemnity provisions there, but I can hardly pick up an agreement off my desk these days without finding an indemnity provision in it that goes on for 4 pages. And sometimes I think we overdo it a bit. And the law of contracts provides remedies and damages. If you have a representation of warranty and there's a breach of a representation of warranty, the law provides a remedy. If you have a covenant and there's a breach of covenant, irrespective of it, you don't need an indemnity to say that you're entitled to recover for that. And without indemnities, in fact, the law of contract and the law of damages is reasonably fair to both parties, and the mechanism for recovering damages and the amount of damages is reasonably well set out and reasonably well understood. So I think sometimes we're a little bit too fast to use indemnities. But let's just talk about why they're in an agreement of purchase and sale, why we'd have them there at all. The first reason that's usually advanced is that, if we'll look at the indemnity language a little bit closer in a moment, but it talks about recovering all of the losses that you suffer if you are the injured party from a breach of a representation and warranty or a breach of a covenant. And again, if you think back to law school and if you were bringing a claim for damages for breach of representation and warranty or breach of covenant, You have to prove that your damages are foreseeable. You have to prove that they're not too remote, and so there are some limits on the damages that you would be entitled to. And those probably won't, in most cases, that's probably not going to be a great concern, but at least in the indemnity, you've contractually entitled yourself to recover all of your damages, and we'll look at that language a bit more in a moment. As you also know, in an ordinary claim for damages based on contract, if you win that claim, or if your client wins that claim, he's going to be entitled to receive a certain percentage of his legal fees as costs in the action or in the settlement. In an indemnity, typically you provide that you're entitled to recover, among other things, all of the legal costs that you incur in enforcing a claim. So you get recovery of 100% of the legal costs involved. And so that gives you a little bit of something that you wouldn't have got just by relying on your common law remedies. The third one, and this is perhaps more important, is that if you didn't have an indemnity provision and you were just relying on the common law right to damages for breach of representation or warranty, if you're not successful, say there was, see if I can think of an example, say there was a claim that there were taxes owing that had been unpaid, and so you're faced with an argument with the Department of National Revenue that you're ultimately successful in. You go to court, you go to appeal, eventually you're successful and your client doesn't have to pay those additional taxes, but he's run up quite a bill in defending the action. Maybe he's had to pay the money over to the Department of National Revenue and then recovered it, but he spent a fair amount of money in defending that action. If he didn't have an indemnity, you wouldn't have a claim for breach of representation or warranty, because in fact the representation or warranty turned out to be true after all. The taxes weren't owing, there was no breach of a representation or warranty, and so you have no claim against the seller of the business. And maybe that's fair, that you shouldn't have a claim. But if you had an indemnity, the indemnity would say that you're entitled to the expenses anytime there's a claim by a third party that there's been a breach of a representation or warranty. So if you had an indemnity in that exact situation, even though you were successful in the case against the Department of National Revenue as to whether or not there were any additional taxes owing, you would be entitled to recover the costs of defending that claim from the previous owner of the business. So that's the first rationale for having an indemnity, is you get this fuller recovery of losses. The second rationale that's sometimes advanced is that representations and warranties are one means of allocating risk, but they're not the only means of allocating risk, and sometimes it's not appropriate. And let me just give you a couple of examples. The easiest one is in an asset transaction, one of the risks is that there will be non-compliance with the Bulk Sales Act. And you could always comply with the Bulk Sales Act, but it tends to be in a practical way difficult to do. So lots of times you decide to waive compliance with the Bulk Sales Act. Now you can't have a representation and warranty that says, I represent and warrant that there won't be any claim under the Bulk Sales Act. Maybe you could do that. But it's more typical to deal with it as an indemnity. You identify the risk of non-compliance with the Bulk Sales Act, you agree how to allocate that risk, but the means of documenting it in the agreement is through an indemnity rather than through a representation or warranty. You have an indemnity which says any loss which I, the buyer, suffer as a result of non-compliance with the Bulk Sales Act, we agree that the vendor will indemnify and hold me harmless against that exposure. Another example, sometimes when you're negotiating representations and warranties, and it was alluded to earlier, the seller will say, well, I can't give that representation and warranty. To take an easy example, you're asking for a simple representation or warranty that the financial statements are true and correct. And sometimes you're met with the argument by the seller that, well, look, the financial statements were prepared by the auditors, not by me. I'm not an accountant. I don't know whether they're true and correct. I rely on the auditors, so I can't give that representation or warranty. And so the answer to that, I think, is to say, well, we're really not talking about, we're trying to allocate the risk that these financial statements may not be correct. And if you can't do it in a representation or warranty, if someone has a problem with giving a representation or warranty over something that they're not personally aware of, you can deal with it through the indemnities. And you can have an indemnity which says, in the event that the financial statements are inaccurate in any material degree, the seller agrees to indemnify the buyer for any loss he suffers as a result of that. So that's another reason for having an indemnity. It's just a different way of allocating risk between the two parties rather than using the representations and warranties. The third reason for that's sometimes advanced for having indemnity provisions, and the one we'll have a look at in a few minutes, is the third-party claim. If you think about the representations and warranties and the claims that might come up later on, there are really two kinds of claims, and they're usually called direct claims and third-party claims, and I'm sure you've seen that language in any precedent you've ever looked at. Direct claims are those which the purchaser suffers itself. You have a representation or warranty that the inventory is good and saleable within a certain period of time. And you go in, your client takes over the business, and as he looks at it, he finds out that there was inventory that was stored that was non-saleable, it was scrap, it was obsolete or something. And so he comes to you and says, you know, we paid $1 million for this inventory, 10% of it turns out to be obsolete. There's a breach of the representation or warranty about inventory, I'm entitled to collect $100,000. That's a direct claim, and it's covered by the indemnity, but it could just as easily be an action for breach of contract as well. You know what the action is, you know who the parties are going to be, you know how to deal with it. But there are other kinds of claims, and let's just go back to the tax example, where there is a third party who is bringing the action, in this case the Department of National Revenue, and alleging as a fact that there are taxes owing, and if the third party is correct, then there will be a loss. And now you're faced, if that comes up, you're faced with the problem of how do you deal with that? Who defends the action? Who's at risk? Who pays for it in the meantime? And a well-drafted indemnity should deal with all of those questions. And that's what occupies, I think, a lot of the drafting, a lot of the wording in an indemnity. And that's the part that it's sometimes hard to read through. But once you've been in one of those sort of actions, and you spent a day or two going back over the language that was in the indemnity and trying to see whether it does work, you sort of read it with a new focus. And so we'll go through that language together a bit. But I think that's one of the most important reasons for having an indemnity in an agreement of purchase and sale, and that's to deal with the problem of these third-party claims which may give rise to a loss. Let me take a second here. I just wanted to walk through the precedent with you a bit and look at it that way. If you turn to the agreement of purchase and sale, it's near the front of the materials. I think it's under tab 1, but it's near there anyway. And the indemnity language starts at section 5.4. I'll give you a second to turn to it. And let me just give you some of my thoughts as we go through that, some of the things that I would be thinking of if I were acting for either the purchaser or the vendors in this cyber store example. And just, if you start at the first sentence, it says, the vendors jointly and severally agree to indemnify. And here we have three sellers. We have a majority shareholder who owns 60% of the shares and two minority shareholders who each own 20% of the shares. And the first question, if I'm acting for them, is why is my guy who owns 20% of the shares, or if I'm acting for all three of them, I suppose I have a conflict of interest and an ethical problem, but why should the 20% shareholder be liable for 100% of any damages? And so the first argument you're going to have is who should be liable on the indemnity and to what degree? If I'm the buyer, I'm saying, look, you guys are a team, you are collectively the shareholders, I'm buying this business from you. If I have a problem with it, I don't have to chase all three of you. I'll get whoever I can, and you can claim contribution and indemnity from each other. But I, as the buyer, shouldn't have to worry about trying to find all three of you and parceling up this risk. And that's an argument that you have every time in this sort of transaction. I always find that I lose if I'm acting for the buyer, and it always ends up with the sellers being successful in limiting their liability to each of the three of them being liable for their pro rata share of any loss or expense. And I think they lose because the sellers tend to be individuals, and they're talking about individual liability. The buyer tends to be a corporation or a larger entity, and when it gets down to brass tacks, people think about their personal liability and dig in at that. But that's an argument that comes up all the time, and one you have to think about, particularly if you're acting for the sellers. The other one is to say, look, if I'm one of the individual vendors, should I be liable on all the representations and warranties, even for my 20%? If it turns out that the majority shareholder has mortgaged his shares and somebody comes along later and said they had a mortgage on the shares or there's a problem, why should I be liable for that? I'm only going to be liable for the things that I know about or I can speak to, and I won't be liable for anything that somebody else knew about or that was, particularly if it was personal to them. So you can be in arguments along those lines as to which vendor should be liable for which parts of the indemnities and the representations and warranties. One of the things we talked about before is who the indemnity should run in favor of. Should it run in favor of the purchaser and the company? In other words, one of the examples that was discussed earlier before is if there's a claim for taxes, that the loss is borne by the company, and does the indemnity run in favor of the purchaser, or does it run in favor of the company, or does it run in favor of both? I think generally speaking you're okay if it runs in favor of the purchaser, only because if the company suffers a loss and is diminished in value, I think the purchaser has also suffered a loss because the thing which he's bought is worth less and he suffered a loss as well. But I always try and put the company in as well. This language talks about the purchaser and its affiliates, and I think affiliates would pick up, we haven't defined it here, but would probably include the company that was just acquired. The next issue, and I'm not sure what the answer to this one is either, is how do you calculate what the loss is? Once it sounds fairly easy. On our inventory example, maybe it is easy. If 20% of the inventory is scrap, and we paid $1 million for it, I may have changed the percentages, but 20% of $1 million, $200,000, that's what our loss is, that's what our claim is. But it may not be that simple. Lots of times companies get bought and sold, especially in the high-tech business, based on a multiple, not of necessarily of what the hard assets are, but on a multiple of earnings or a multiple of revenues or some other factor. And so how do you decide what the loss is? If you claimed I had revenues of $2 million and I bought this company at twice revenues and paid $4 million for it, if it turns out that there's been a breach of a representation or warranty and the revenues were less than anticipated, if they're less by $100,000, what is my loss? Am I just out that $100,000? Or can I say, well, look, I bought this business, I valued this business on a multiple of revenues, and so I should be entitled to, if the revenues are $100,000 less and I paid twice revenues, I'm entitled to $200,000. And as the purchaser, I mean, how I valued this business may be entirely confidential to me. It may never have been disclosed, and even if it was disclosed, what role does that play in valuing what my loss is? And if you look at the precedent, the way that I've tried to deal with this is to say that the loss includes a diminution in value. And that at least brings in the concept that a loss may be more than just strictly a dollar for dollar loss. And conversely, if I'm acting for the seller, I have the same worry in trying to calculate what my liability is, what my client's liability is. And sometimes I'll try and put in language which says, in calculating the loss will be dollar for dollar in the loss of revenues or whatever the liability is. But it's not as simple as it sometimes looks on first blush to figure out what the loss is. Now, then we go on to say, if just continuing down section 5.4, what do we indemnify against? And the first thing is sort of as you would expect, breach of or incorrectness in any of the representations and warranties made under the agreement. And that's the most common. The indemnity should in every case will go to that. So that's fine, that makes sense. And then if you flip over to B, a breach of any of the covenants in the agreement. And again, that makes perfect sense, and every indemnity I think should cover those two things at least. But again, if we didn't have any indemnity, we'd have a common law action for breach of representation or warranty or breach of covenant. Now, once you get past those two, there starts to be some question about what else should be covered by an indemnity. And really, we'll go through the rest of these examples, but now we start to come across things that maybe could have been dealt with in a representation and warranty, and maybe they are dealt with in a representation and warranty already. And sometimes you find yourself negotiating the same battles twice in an agreement. You've argued about what the representation and warranty should be, and you've settled that, and then you come to the indemnities, and you find you're having to argue the same thing all over again because the person who's drafted the agreement is trying to get the same protection through the indemnities that he's gotten through the representations and warranties. So you can't quit reading the agreement when you get to the indemnities. You have to keep reading to make sure you don't lose here what you've gained in the earlier part of it. And if you look at C, we try and say that we're looking for an indemnity against any litigation arising from circumstances that existed prior to the effective date. And that's a very broad indemnification, and maybe it's appropriate, but we already have a representation or warranty dealing with litigation in the agreement, and so here we're really trying to, we may be covering the same ground again. D is an indemnity with respect to taxes, and it says any liability for taxes other than to the extent taxes are reflected on the closing date balance sheet, we've taken them into account in setting the purchase price. But if there is any other assessment for taxes that haven't been disclosed, we're looking for an indemnity. And again, that indemnity may overlap with the representation and warranty that deals with taxes, and we'll want to make sure there isn't a difference between them. The next two deal with matters that are more clearly dealt with in representations and warranties, and they're receivables and inventory. And I've included them just as examples of a way to allocate risk because they go on to deal with how to deal with uncollected receivables and how to deal with unsaleable inventory. And so they're worth reading, not because I'm trying to suggest you should have both a representation and warranty dealing with inventory and receivables and have an indemnity, but just because they're interesting examples of how to calculate what the loss is and how to deal with it. They have mechanics for putting the uncollected receivables back to the purchaser. They have rules for dealing with how to decide what inventory was sold and when it was sold, and first in, first out sort of concepts. So they have mechanics for dealing with losses on inventory and receivables. G deals with employment and labor law matters, and again tries to put all of the risk for undisclosed matters back onto the seller. And I think this one is really repetitive of what's in the representations and warranties. If I was acting for the buyer, I would just cross all these things out. I would have left in A and B, breach of representation, warranty, and covenant, and crossed everything else out. So don't be afraid to take a red pencil to these sorts of agreements when they cross your desk. I think in this case the precedent probably is overreaching. The next point I wanted to talk about, and this one is a little bit, I think we may gloss over this too quickly, is how long should the representations and warranties last? How long should you be entitled to claim indemnity? And I think someone asked Hugh that question with regard to the IP reps and warranties. And sometimes we answer this question a little too easily, I think. You say, well, the sort of range is between 1 year and 5 years, and 2 years is kind of normal, and so we'll agree at 2 years and everybody will go home. But I think that's too quick an answer. And really, if you step back and say, why should there be any time limit at all on these representations and warranties? If my client's paying a lot of money to buy this business, he's not going to be particularly happy with me if he finds out 2 years from now there's a problem. And I say, well, we had this great agreement, okay, and we had these great representations and warranties and these great indemnities. Unfortunately, they've expired, and you no longer have any claim at all. And if I'm a client, why would I accept that? Any sort of limitation. And again, if I didn't have an indemnity, if I was just relying on my common law rights, I would have the normal limitation period, which would be at least 6 years to bring an action. So you have to be sure that you're not worse off under the indemnity provision that you've put in your agreement than you would be if you had your common law rights. And I guess one of the reasons that the time limitation is in there is that, you know, if I'm the seller, there are certain problems that are probably going to come out fairly soon, and if you haven't complained about them within a reasonable period of time, you shouldn't bother me again. And those are the sort of the typical revolving business assets like inventory and receivables. If there's a problem with the receivables, you're going to know fairly quickly. If there's a problem with the inventory, you should know fairly quickly. If you audit the financial statements, by the time you've turned around one set of financial statements and your auditors have been in there, they've kicked the tires, they've signed off on the financial statements, they've gone through the process and procedures that they need to do to satisfy themselves that the financial statements accurately and fairly present the financial condition of the company. Once you've done that, you have some assurance that things are as you expect them to be, and I, as the seller, should be let off and not kept on the hook anymore. I want to put an end to this liability that I've taken on. And for a lot of things, I think I could accept that argument if I'm acting for the buyer, especially on things like inventory and receivables. But there are other things that, you know, title to the shares. We're buying shares in this agreement, and if it turns out that there is a problem with the title to the shares that I've acquired, whether it's 2 years from now or 22 years from now, other than statutory limitation periods, I don't think my client, as the buyer, should have any restraint on his ability to seek indemnification. And if I were the client, I would be particularly annoyed if I found out that my lawyer had given that away. So there's some things like title that I don't think there should be any limitation period on, or if it is, it better be a limitation period that exceeds the statutory limitation period. In intellectual property, it may be, we may hear about this from Rob in a few minutes, but you know, if the problem's not going to surface for 2 years or 5 years until some period of time down the road, then I don't think there's any rationale for the indemnity expiring before the time that a problem would likely surface. Environmental issues are, again, something. An environmental problem may be latent. There may be problems in the ground that we didn't pick up in our due diligence, and we may not find out about it until we go to sell the property or until an adjoining landowner starts complaining when he does an investigation of his property and finds out that the oil that we were plowing into the back 40, which has seeped into the groundwater, is now migrated onto his site, and he has a problem. So things like environmental representations and warranties, I think, should last for a very extended period of time because the problem may not be discovered for some period of time, and it's certainly not going to be discovered by the auditors, you know, preparing financial statements at all. There are other things like taxes, and I guess in most precedents that you look at, you'll see that there is an extended time period for taxes. You don't want to find out that the tax department has 5 years to reassess your client and your representation and warranty expired after 2 years. So you want the representation and warranty and the indemnity as far as it relates to taxes to last longer than the time that the Department of National Revenue has to come back and reassess you. So again, if we just look at the agreement of purchase and sale, subsection 3 talks about the time period, and again, this is a fairly simple one. Maybe depending upon the facts, we'd want to say it's going to be 2 years for the representations and warranties dealing with financial statements, dealing with inventory, dealing with receivables. It's going to be forever with respect to title. It's going to be 10 years with respect to environmental matters, but I think you want to look at each of the representations and warranties and ask what makes sense, and think about if you were a client, what would make sense to you, and not just simply decide that sawing off between 1 year and 2 years is you've done your job by doing that. If you flip the page, the other limitation that I wanted to talk about a bit was the monetary limitations. And this one, if you look at section 5.6, we've said that there's no indemnification claimed under the agreement until the accumulated aggregate amount of claims reaches a certain threshold. And again, if I'm a client, why is that provision in there? And there are a couple of reasons that are advanced for that. One is just a practical reason. You're not going to start a lawsuit over a de minimis amount of money, and so it makes sense to put in a claim which says, until it gets to be $25,000 or $50,000 or $100,000, there's no right to indemnity, and because no one's going to bring a lawsuit over that amount anyway. I'm never convinced that that really makes sense, because if it's true, then you don't need the limitation. No one's going to bring a lawsuit for a small amount of money, so why bother trying to negotiate something? That will take care of itself in the practicalities of whether or not to bring a claim. The rationale that makes more sense to me is to say, look, valuing a business is not an exercise in exact science. When you decide to pay $1.5 million for a business or $15 million for a business, that number hasn't been arrived at with any great mathematical precision. And there are going to be warts in any business. There are going to be problems with it. Anybody who buys a business should expect that some things will be a little bit different than were represented and warranted. Some things will be a little bit worse. On the other hand, some things will turn out to be a little bit better than you expected them to be as well. There's some sort of swings and roundabouts, there are ups and downs. And so I think you can make a convincing case to say, look, if we are within a certain percentage, if you buy a $15 million business and the total number of problems is less than 2% of that number, then you've substantially gotten what you've bargained for as a purchaser, and you should be satisfied, and I as a seller shouldn't be exposed to any claim. In other words, don't bother me unless it's really something material, not in relation to whether or not it makes sense to bring a lawsuit, but in relation to what you bought and did you get substantially what you bargained for or not. And I think that rationale can be convincingly argued, and the number that I sometimes, that seems to be accepted by most people is, if you got 98 or 99% of what you contracted for, then you have a good deal, and you should be satisfied with it, and I as a seller should be able to walk away from it. So I oftentimes see a threshold of 1 or 2% negotiated. It tends to be that the larger the purchase price, the smaller the percentage is, but I'm not sure you can make a case either way on that. The next case is, if you accept that, once you've reached that amount, say it's 1% of the purchase price, do you then, if you bring a claim, do you bring it only for everything that's above that? If it's say a $10 million purchase price, 1% is, if my math is right, $100,000. So you say, okay, there's no claim at all under the indemnity until your losses in the aggregate exceed $100,000. Then once your losses are $110,000, do you then bring a claim for $10,000, or do you bring a claim for $110,000? And I don't think there's any convincing argument one way or another on that, and it goes both ways. But just be careful how you draft it, and make sure you understand and that your client understands the way it's been drafted, so that they appreciate that there's a distinction between that, those two types of clauses and the effect that they will have. The other thing that we see, I think, more and more of in indemnity provisions, and it's not in this precedent, is if I'm the seller, I would like to have a cap on what my liability is, on what my total exposure is under the representations and warranties. And lately, I see in most deals sellers stipulating for a cap on their maximum exposure. And the obvious one is to say, well, my liability shouldn't exceed the amount of the purchase price. If I'm selling shares and I receive $10 million, then my maximum exposure should be $10 million. Because no matter how bad the business is, I could have always just allowed it to go bankrupt, and I would have lost my investment, but I wouldn't have lost anything else. And so if the cap on my liability is $10 million, well, I received $10 million, and if in the worst of all worlds, if I have to pay that out on an indemnity claim, then I've received essentially nothing for my business, but I'm flat. I'm in the same position I would have been in had I just allowed it to go bankrupt. And so I will not accept any personal liability beyond the purchase price. And so you see lots of agreements where there's that kind of cap on the seller's exposure under indemnities. I've seen in agreements recently where sellers have been able to negotiate much better deals than that, with their liability being limited to 20% or 10% of the purchase price. And I think that's the trend in agreements, as I see it, is that sellers negotiating for lower and lower caps on their exposure. Again, if I'm acting for a buyer, I'm not persuaded by that. Of the two of us, the one who knows the representations and warranties best is the seller. Of between my client, the buyer, and the seller, the one who I think should accept the risk of a large claim is the seller. It's his business. He's the one who's made the representations and warranties. He's the one who had, of the two of us, the best knowledge. So if there is a claim, he should be responsible for it up to the amount I've lost, and whether or not that exceeds the purchase price is irrelevant. If I've invested more money in the business, so I've lost not only what I paid for it, but some additional amounts as well, I ought to have a claim over against the seller for that. But again, my experience is that sellers are getting more and more aggressive in negotiating limits on their exposure. One of the things we talked about, it doesn't come up in this example, but more and more transactions I'm seeing, even in private companies, are being run through an auction process where the seller has invited a number of prospective buyers to come in and kick the tires, to do some due diligence, and to mark up an agreement of purchase and sale. And then the seller accepts one of those agreements of purchase and sale, or goes on to negotiate a definitive agreement with that person based not only on the purchase price, but on the markup of the agreement of purchase and sale. And in those cases, sellers are stipulating for very limited exposure on their indemnities, and your client is faced with the prospect of putting in an unattractive offer by marking it up too heavily, or being the one that ultimately bears the risk of a substantial claim. The last thing I wanted to talk about before I ask Rob to say a few words from an IP standpoint are the third-party claim mechanics, and they're in section 5.9 of the agreement, and they're worth looking at to give some thought to. If we just take the example of the income tax claim, we've used that twice already. And the issue is, if there is a claim by the tax department a year after the transaction is closed, the tax department is saying, look, we've gone back and re-looked at the financial statements and at the transactions that have taken place, and we think there's another $500,000 in tax owing, and we're going to issue a notice of assessment, and you have to pay that $500,000 within 30 days or 60 days. And if you want to object or appeal, you're entitled to do that, but you have to pay the money anyway. If I'm the buyer and it's counsel, I go and look and I say, did I have a representation or warranty dealing with taxes? And yes, luckily there was one dealing with taxes, and it seems to say that I have a claim for breach of representation or warranty. And then I read the indemnity section and say, am I entitled to an indemnity? And I read that, it says, yes, I'm entitled to indemnity, and the time period hasn't expired. And then I look to see, what are the thresholds, what are the caps? And then next, do I have to give notice? And then the next thing is, who's going to be dealing with the tax department? Who's going to be responsible for arguing the case? Who's going to pay for arguing the case? Who's going to appoint the counsel to do it? If the other party, if the party who's the seller who is providing the indemnity, it's their money, so the agreement is quite often going to say they're entitled to take control of that matter. But as you know, in negotiating with the tax department, it's I as the buyer, it's now my company. I may have a different attitude to how these negotiations with the tax department take place. So all of a sudden, I'm reading these third-party claim mechanics a lot more carefully to say who's in control of that process. Is my client in control? If not, do I have the right to participate? Do I have the right to veto those negotiations? What happens if there's settlement discussions? All of a sudden, I have a much greater interest in this than I had before. The next thing is, as I said before, I still have to pay the $500,000 to the tax department while we're arguing about whether the taxes are due and owing. And does my client have to pay up this money? Or does the seller have to pay up this money? If you look at this precedent, I think it says that the seller, the person providing the indemnity, has to pay up the amount of money in dispute. And that will make a big difference to my client and a big difference to the seller. So those third-party claim mechanics, it kind of looks like boilerplate, but when you're reading them, try and read them with the context of there is a problem, and you're trying to now read them not just out of some academic exercise, but read it from the perspective of it's now 18 months from the time this agreement was signed, and I'm trying to make this work in my client's favor, and read through the mechanics to see whether they actually do work. There's tremendous variation in precedents, and it's not boilerplate at all, and lots of times the drafting just doesn't work, or it doesn't work from your client's standpoint. So sometime when you're going through the agreement, don't start at the beginning, start at the middle or at the end, and read those indemnity sections and try and read them carefully because there's a lot in there. Anyway, I wanted to ask Rob to come and spend 2 or 3 minutes talking to us about the intellectual property aspects of this topic.
Thanks, Greg. As Greg said, I have, well, now 2 or 3 minutes, so I'll try to keep to that. I'm going to try and talk about indemnities and remedies as they relate specifically to a computer-related business and intellectual property. If there aren't any ceilings and there aren't any time limitations and there aren't any exclusions from certain types of damages in the indemnity, then I really don't have any issues from a purchaser's point of view. We're fully protected as long as the indemnity covers third-party actions, recognizing that most intellectual property issues will involve a third-party action and not necessarily a direct claim. If there is a ceiling or a time limitation or exclusion, I do have some issues. Greg and Neil mentioned in their paper, and I think Greg mentioned again, that sometimes you'll have a ceiling on the liability. For example, because damages in an environmental case could exceed the purchase price. Well, the same's true in an intellectual property dispute. And again, the vendor's the one that knows how the business was conducted. Now, there's some counter arguments from the vendor's point of view. For example, patents can be innocently infringed. We talked about that a bit before. So perhaps the seller shouldn't be liable for something like that. Maybe there can be a carve out. You get rather complicated and it can get nasty, and generally my corporate commercial guys will come back to me and say, give me a break. But let's keep this thing simple. If we start taking things out of it, we're going to be here forever. But if you're into that argument, these are the kind of points you can use. And from the purchaser's from the seller's point of view, the purchaser is the one getting the revenue from the business going forward, so why shouldn't they accept the risk going forward on a patent infringement suit? Time limitations are a bit scary in an intellectual property action. Greg mentioned some of the problems, but a lawsuit and a patent may not occur for many years, and once it starts, it's not going to be over for a great many years after that. So does the time limitation apply to when a final decision is made and a judgment's handed down, or does it stop at some earlier time, say 1.5 years after the agreement's been signed, whether or not an existing lawsuit's been resolved? In some instances, it's a bit odd, but I've seen in some instances sellers trying to exclude liability for things like consequential, special, and indirect damages, and that's really something that's coming out of U.S. commercial licensing agreements. And if you see something like that as a purchaser, you just take it out. To the extent it means anything in Canada, it may exclude indemnification for third-party actions. Also, as Greg mentioned at the end, related to tax matters, in some cases the vendor will only indemnify if it's given control over the defense of a third-party action. And obviously in that case, you don't want a ceiling and you don't want a time limitation. They shouldn't apply because the vendor now has control over the action. And they could string you out and then walk away once one of those thresholds has been met and you're in the middle of an action that you had no control over. And also any settlement by the vendor should only be with the consent of the purchaser, because a settlement could involve some kind of a forfeiture of the intellectual property rights, for example, and you're going to want to have control over that. And in fact, a poor defense could involve the forfeiture of your intellectual property rights, and that's one reason why I just don't like to give up control at all of the lawsuit in the first place if I'm the purchaser. And that's my comments on indemnities. And once again, thanks for listening. And if you have any questions, let us know.
Any questions?
I think it's the end of the day.
Okay, well, thank you very much then. Thank you for your patience and sticking it out for the whole day. Just to clean up matters, if you would try and find the form in the front of your book, the reporting on how you found today's session, and drop it off at the front. I know the Law Society appreciates getting those forms back. Secondly, if you want a copy of the diskette, I think it's available both on Word and WordPerfect. So if you have a strong preference as to how you get your diskette and you've handed in the form already, try and dig your form back out and put down whether you want it on Word or WordPerfect. Or if you want both, I think they can give you both as well. Thanks very much.